My paper will discuss the two mechanisms that the UN Human Rights Council uses. This paper will address the two mechanisms that the UN Human Rights Council uses for grave crises or mass atrocities. And the purpose really is to provide the kind of information from the UN human rights system that will complement the keynote that we heard this morning. The keynote was really about treaties and treaty monitoring bodies, which are legal or quasi-judicial, whereas the UN Human Rights Council is by its very nature political. It's an intergovernmental body. And I want to look at how or whether this political body can be useful in addressing crimes against humanity from a human rights perspective. The Human Rights Council, just to give a brief background for anyone who doesn't know, is the main UN human rights body. It's not an organ, it's a subsidiary body of the General Assembly. It has 47 member states, and they're elected for 3-year terms. And those member states send diplomats as their representatives rather than independent experts. And those diplomats are there to represent government interests rather than with particular expertise on human rights. Now, of course, some missions to Geneva will have more people within the mission and therefore more expertise on human rights to inform the ambassadors. But we expect that the ambassadors will act in a political way. Where you have political objectives and a political body, you will necessarily have politicization. Countries will use their membership of a body to advance their own national objectives. And sometimes those objectives and agendas are related to human rights, and sometimes they have nothing to do with human rights, and sometimes they're looking to undermine the human rights project. Now, I could talk about politicization at great length, but I won't. But just to say, politicization is absolutely crucial when we're thinking about how the UN Human Rights Council can and should be acting where it comes to these grave crises or mass atrocities. In particular, we need to think about the types of politicization that comes from blocks or groups of states who will vote together or act together or use their political or economic power to push other countries to act with them. And in particular, the main blocks that operate at the UN Human Rights Council are the Organization of Islamic Conference, which has 57 member states, the European Union, which was the first political bloc really to act within the United Nations. And to a greater or lesser extent, we see other emerging political blocs like BRICS, who are gaining more and more power within the Human Rights Council. The Council's mandates are to promote, protect, and develop human rights, but it doesn't have the powers really to protect in the way that legal institutions have those powers or in the way that the Security Council has those powers. But where it comes to mass atrocities, grave crises, crimes against humanity, what the Council really needs is to be agile and to be able to protect and prevent in those circumstances. And this is where much of the criticism comes from when people are looking at the Council. They expect it to act, and they don't understand that it doesn't have the powers to take such actions. But it has been given two mechanisms that are agile, that are responsive, and that are used where it comes to these types of mass atrocities. The first is the mechanism of fact-finding missions, the ad hoc mechanism, sometimes called commissions of inquiry. And the second is special sessions that can be called by the Council. I'll deal with them both separately, and then I'll try to bring together some lessons that we can learn in terms of understanding whether or how the Council can help with advancing the project that this conference is focused on. Fact-finding mechanisms are investigative mechanisms that the UN can create. And it's not only the Human Rights Council. The Security Council has created them, the General Assembly, the High Commissioner for Human Rights. But I'm only going to look at the Council. These bodies that are mandated by the Council can take the form of fact-finding missions or commissions of inquiry. Most have been established to investigate violations in specific countries rather than thematic violations across a region or the world. They're established by resolutions at the Human Rights Council, and they can have a broad range of activities. They might be there to monitor, to report, to investigate, to fact find, to preserve evidence, to make recommendations, or to feed into accountability and other mechanisms looking to address these grave violations. But of course, there are challenges with both the creation and implementation of these mechanisms. First of all, there's politicization. There have been 37 ad hoc mechanisms created since 2006, when the Human Rights Council replaced the Commission on Human Rights. Of those 37 ad hoc mechanisms, around a quarter have been on Israel and the occupied Palestinian territories. By contrast, there's only been 2 on Syria, 2 on Sudan, despite the genocide in Darfur in 2008 and again this year, the mass displacement of 6 million people and 20 million people facing hunger. 2 on Myanmar, 1 on North Korea, and 1 on ISIS, and only ISIS specifically in Iraq. So we can see politicization already. The fact there has been none on China whatsoever. We can see politicization that manifests through disproportionate or excessive scrutiny of one country in order to take resources away from being able to create mechanisms on other countries or mass atrocities or situations of grave violations. Because there are finite resources, as we know, finite time resources, finite financial resources, and finite ability for the Council to create any mechanisms to address human rights problems. Now, once we understand that there is already politicization in which countries or which mass atrocities the Council looks at, we need to think about why those countries, we need to think about why countries receive no scrutiny whatsoever. So of all of the mandates, the only one that looks at the violations by a P5 country is the recent Commission of Inquiry that was set up on Ukraine. And we can see that that was set up, as we know, because of the UN being seized of this issue and the Security Council being impotent to act and the Human Rights Council being expected to take up the mantle. That is the same as the Security Council's impotence to act on Israel and the occupied Palestinian territories, and the human rights bodies being expected to pick up the mantle and do something to take it forward. But we know that there's not been any ad hoc mechanisms on China, for example, or on the United States, but also on other powerful countries around the world where grave atrocities have occurred. We know that those countries can use their economic and political power to pressure their allies or even other states from their regional groups, political blocs, or elsewhere to block scrutiny of the types of egregious situations that we'll hear about in other papers in the panels over the next 2 days. The second issue or challenge for these mechanisms is that even where they are established, states have sovereignty over their own territory, and they can refuse to allow the experts into their countries, do the monitoring, the investigations, the reporting, preserving evidence, and so on. And that clearly hampers efforts to fulfill their mandates. We can briefly contrast the Commission of Inquiry on Ukraine, where the country clearly has an interest in allowing the experts in engaging with them and facilitating them to do their jobs. We can compare that with the recent mandate, the recent fact-finding mission created on Iran as a result of the slaughter of many young women and some men around the issues to do with head coverings. Iran has never let in the independent expert, the special procedures mandate holder on Iran. So it's very unlikely that it will allow this new fact-finding mission in to do their jobs. And of course, they can write reports from outside of the country, as the fact-finding mission on Darfur did nearly 20 years ago, by meeting with political dissidents, by receiving reports from civil society. But that does not go far enough in terms of preventing and remedying the types of mass atrocities that are going on the ground. The second mechanism that I want to discuss is special sessions. The Council meets at least 3 times a year for at least 10 weeks of the year to discuss standing agenda items. But where mass atrocities or grave violations are occurring outside of council session time, the council has this agile and responsive mechanism called special sessions that can be convened at very short notice to respond to these types of atrocities. You need 1/3 of the council members to request a special session, and they usually last for a day, sometimes 2 days. They allow states, civil society, other stakeholders, such as the High Commissioner for Human Rights, special procedures mandate holders, and others to present their views on the issue at hand. Many of the ad hoc mechanisms, the commissions of inquiry, have themselves been created as a result of resolutions passed at these special sessions. The key thing that they do is to shine a spotlight on the atrocities occurring. So unlike the commissions of inquiries, they don't go into the country to look for evidence, to preserve evidence, to do investigations and monitoring, but rather they're held in Geneva and the information is shared in a very public way. It's webcast, it's compiled together afterwards and used to feed into, for example, Security Council discussions maybe on a situation. They're very much seen as an early warning system, not only for the United Nations, but for civil society actors and for other regional actors to pick up on the information that's shared and take forward how best to prevent these atrocities from continuing. Again, the council doesn't have the power to take action, so its role here is really to facilitate fact-finding, information sharing, capacity exchange in terms of knowledge. Again, these special sessions have been politicized, which we expect because the council is by its very nature a political body. In fact, one of the former High Commissioners for Human Rights used to say you can't criticize the council's predecessor, the commission, for being politicized any more than you can criticize a fish for being wet. It is just part of its nature. The problem is where the politicization becomes so selective that it undermines the council's work. And we know that special sessions have again been politicized in terms of the numbers, particularly the numbers on Israel and Palestine, but also the numbers on Syria, compared with grave atrocities, particularly occurring in countries in Africa, which receive very little attention in comparison. The reason I wanted to discuss or flag or just talk about these two mechanisms is that they are a key way of taking forward the global human rights framework's response to crimes against humanity. The human rights system works because it is a system. And while I fully agree with the keynote speaker this morning around the need for a treaty and a treaty monitoring body, there also needs to be that political push and the use of the council's mechanisms. Unlike the treaty monitoring bodies, the council has a universal mandate. The treaty monitoring bodies require states to be party to the treaty, whereas the council has a mandate universally over all members of the United Nations. What we can see is that using the UN Human Rights Council to protect against crimes against humanity will be selective in terms of which situations receive attention and which do not. Right? They will be politicized, but that does not make the mechanisms redundant. We need to be realistic about when these mechanisms will be useful and when they will not. Human rights lawyers are idealists by our very nature. The human rights law sets out the ideal that we want to happen, but we need to do what Anne-Marie Slaughter talks about in terms of bridging the gap between the ideals of human rights law and the realities of international relations in practice. These mechanisms can be used and useful for some crisis situations, as we have seen in terms of the excellent work that's being done by the Commission of Inquiry on Ukraine. They provide time and space for monitoring, fact-finding, information sharing, and all of these can and should be used to inform other institutions and stakeholders working on preventing mass atrocities. The mechanisms are one piece of the puzzle of how the global human rights system can help to prevent crimes against humanity. They should not be overlooked. But we have to remember as human rights lawyers not to be idealist about what they can do. We have to be realistic about their limitations and challenges, and particularly the politicization that besets them. Thank you.